This panel is on conservative and libertarian alternatives to originalism. You may wonder about this. After all, originalism is undergoing a huge revival. We have all kinds of originalism. We have people who've gone back to the old originalism of intent, and people like Richard Kay. We have people defending the next move in originalism, the simple public meaning originalism. Mike Paulson. We, of course, have the new originalists, so with Randy Barnett and Keith Whittington and Larry Solom. We even have people who are original methods originalists. In fact, I think it's fair to say we have an originalism bubble. Hence the panel. Because we're going to get out in front. This means that their academic fads must be going elsewhere. Or to put it more seriously, of course, serious intellectual inquiry is going to go elsewhere now that people are exhausting the market in originalism. Or perhaps another way of thinking about this is we want to look at conservative and libertarian alternatives to originalism as a kind of interorum for people who are not originalists. Here's what we will do if you go down that non-originalist route, something really bad, worse than originalism. But more seriously, I think it is the case that there hasn't been enough thought to conservative and libertarian alternatives to originalism. There's no doubt, as someone who's worked in the originalism vineyards himself, there are problems in originalist theory, and it's not certainly beyond the intellectual imagination to think those problems are serious enough that one shouldn't think about alternatives. And yet it appears that most of the alternatives of non-originalism or non-interpretive theories lean, at least in our era, sharply to the left. And there doesn't seem to be any necessary reason that should be true. And I'm very happy that we've therefore put a panel on alternatives. Where I'm not going to introduce the speakers who need no introduction. We really are going to move from theories that are already fairly well defined, like natural law, to less well defined alternatives, and that's the theory about the ordering of the speakers. And so we'll begin with Patrick Brennan to talk about the natural law alternative to originalism.
Good afternoon. It's a pleasure to be here. I apologize in advance that I'm going to have to leave a little bit early. The panel was originally scheduled for earlier in the afternoon, and I have another commitment that requires me to leave prematurely. Along with the other panelists, I've been asked to talk, as John said, about an alternative to originalism, not about the merits or demerits of originalism itself. In order to ensure that I'm proposing an actual alternative, however, not just originalism by another name, I need to say something about what I take originalism to be, especially because the alternative I shall defend comes in several respects quite close to some versions of originalism, though not to others among those John mentioned. One version of originalism, the one I suspect is most popular among those gathered here, proposes, as you know, that the legally enforceable meaning of the Constitution is the original public meaning, which makes it, I think, a form of the new textualism that I suspect is also very popular among those gathered here. For reasons to which I shall come, though, and at the risk of sounding alarmist, I think this version is not only wrong-headed, but subversive, whatever its advocates' good intentions. We know where they lead. Another version of originalism proposes that the legally enforceable meaning of our Constitution is what the drafters and ratifiers intended and enacted. It's to this second variation on the theme of originalism that my alternative comes, in some respects, quite close. I haven't in the past suggested a name for my alternative, but the press of this occasion prompted me to name it, at least tentatively, legalism. I'm not wholly satisfied with the name because of its connoting pharisaical superciliousness about law and rulemaking. Stripped, though, of its connotations that I just mentioned, the name succeeds if it announces that my theory of legal interpretation is a function of, indeed is entailed by, a theory of the essence of law, more specifically, the very definition of law itself. The fact that law is already defined, at least in a rudimentary but intransigent way, before we humans set about making law and interpreting law or theorizing about law, is the bedrock of my account. How is this even possible, you might ask? Because, I answer, before we humans make law or theorize about the law we make, the natural law already exists. And the natural law is just, as I understand it, following Aquinas, our participation in the eternal law. Some theorists of the natural law, some familiar theorists, such as John Finnis, try to get by without the eternal law. But, for reasons I don't have time to explore here, I regard Finnis's and those who follow him as an estimable but failed project. On the metaphysical account I affirm to be true, the natural law is our human participation in the eternal law, which is, in turn, the divine mind directing all things to their created ends. Or, to put it another way, the first instance of law is the divine ordinance, the eternal law, promulgated by God through creation for the common good of the whole of creation, and the natural law just is our participation in this promulgation. From this first instance of law, Aquinas derives his definition of all law, an ordinance of reason for the common good by him or them who have care over the community and promulgated. In the case of the eternal law and our natural law participation therein, God is the one who has care of the community and does the promulgating. In the case of human law, historically, sometimes it's a prince, sometimes a legislature, sometimes a court, sometimes maybe even an agency that has the relevant care over the community and does the promulgating. Sometimes, however, it's the whole people, perhaps through representatives that have care over the community and do the promulgating, as in the case of enacting and ratifying a constitution. Given the definition of law that I affirm to be true, that we are given by the higher law and by which we are obligated, it follows that in interpreting law, including the Constitution, what we are looking for is the meaning the lawgiver had in mind and promulgated. No lawgiver, no law, at least not strictly speaking. When we have a lawgiver promulgating an ordinance of reason for the common good, we have law, and that's what those interpreting it should look to. As an aside, it might be helpful to note that my position comes very close to the one defended by Larry Alexander. Although he reaches it for different reasons, certainly not, as those who know, on the basis of the natural law, I agree with Alexander that, quote, all texts are attempts by their authors to communicate, and therefore texts, and the italics here are Alexander's, texts mean what their authors intend them to mean. Take away the author's intentions, and you fail to have a text. If the proverbial, and I continue to quote, if the proverbial 1,000 monkeys cavorting on typewriters produced Moby Dick, it would be incoherent to ask, for example, what Ahab's quest for the white whale meant, close quote. For this reason, I also agree with Jack Rakov that in the quest to know the framer's meaning, we will want to know their intentions. As Rakov writes, quote, intention connotes purpose and forethought, and it is, accordingly, best applied to those actors whose decisions produced the constitutional language whose meaning is at issue. Knowing why they preferred one term to another is surely relevant to recovering the original meaning of the Constitution, close quote. Frequently, however, and there's no denying or exaggerating this, the meaning will be difficult to discern, the lawmaker's communicative intentions hard to ascertain. This is one of the problems original public meaning textualism is designed to solve, obviously. It substitutes probable meaning for the lawgiver's actual meaning. The price, though, is too high to pay, and this is the point I would like to underline. It falsifies the very definition and nature of law, and in the process shortchanges the lawgiver. The lawgiver wants, and this in virtue of his or her office, for his or her actual rational will to be obeyed by the people to be ruled, not for the people to follow what they think happens to be his rational will. To put the point still more sharply, It's the lawgiver's right to have his rational will be done, not what accumulation of dictionary definitions yields. Judicial imposition of original public meaning, originalism, is a power grab at the expense of the lawgiver. If it's frequently difficult to know the lawgiver's communicative intentions, there's an aid to interpretation that also comes from the very definition of law itself. Like the eternal law that provides us with the definition to which all law must conform, if it's to be law in the full focal sense of the term, human law must be, if it's to be law at all, for the common good. That's part of the definition. For this reason, the search for original meaning intended by the lawgiver involves interpreting ambiguous texts in light of a necessary presumed purpose on the part of the lawgiver to achieve what is good for the community. For this is the point of all law, to make the natural law effective in our living. And what the natural law commands is that we seek and do the good and to avoid evil. In sum, the theory of interpretation called legalism, at least for now, that I'm defending, is the view that all law is an ordinance of reason for the common good, first in the mind of the lawgiver and second in the mind of the ruled. In the case of the Constitution, the lawgiver is the people themselves. It seems to me that it's a perverse theory of law that would deprive the people of their law-making power. It's a theory of law that respects the lawgiver, the people in this case, that seeks to make his or their promulgated will, his or her or their meaning, their intentions and purposes effective in the community. One last point before I conclude. Up to this point, I've emphasized that my normative account of interpretation follows from the definition of law. I'd like to end by complementing this by underlining that it is even more primordially, if you will, the case that my theory of interpretation follows not just from the nature of, well, not just from the definition of law, but from the nature of the lawmaking role itself. On the traditional natural law account, the lawgiver is a participant in the social kingship of Christ. Christ is the king of all creation, and those who make and enforce human laws are the properly designated sharers in this unique kingship and law-giving authority. This is not a view you will hear very many places, but I'm grateful to the Federalist Society for creating a panel in which this, the traditional view, at least gets a fair hearing. Thanks very much.
Kerr will now do, I think, a Burkean take on law.
Thank you. It's a pleasure to be here, especially someone who's not a constitutional theorist, to talk about constitutional theory. So the way I approach the problem of constitutional interpretation, I think the major evil is confirmation bias. Everyone can look at the Constitution and see what they want it to be, and come up with a theory that magically reaffirms all of their priors. So, liberals have a liberal theory of the Constitution. Libertarians have a libertarian theory of the Constitution. Everyone has a theory of the Constitution which they will swear has nothing to do with their personal political views, but which just so happens to very nicely match their personal political views. And the way I look at constitutional interpretation is that the very first requirement of a theory of constitutional interpretation must be that the views of the speaker do not determine what the personal opinions, preferences, policy views, political ideology of the speaker should not be the determinant of what the Constitution means. The Constitution must have a meaning outside of that. If this were the early 18th century, I think we could all be originalists and satisfy that goal. The difficulty becomes what to do in the 21st century when we have 200 plus years of non-originalist decisions on the books for judges to work with. The difficulty, I think, with originalism is that the preferences of the speaker come into play not through the originalist analysis, but through the choice of what issues to be an originalist about. And an example of this in my own area is the Sixth Amendment right to counsel. It's pretty clear that historically that was meant to be, if you had a lawyer, you were allowed to bring your lawyer into court. You had a right to counsel if you could afford a lawyer to bring. That was in contrast to the common law rule, which was that defense attorneys were flatly forbidden for fear that defense attorneys would trick the jury into acquitting somebody who should not be acquitted. Now we think, well, that's what they're supposed to do. English common rule, not something they wanted to avoid. I don't know of any originalists who have advocated returning to the original intent of the Sixth Amendment and saying that there should no longer be a right to state-provided counsel. Everyone seems to like the Gideon versus Wainwright rule, and so no one challenges that one. And so what I think the problem is that the originalism tends to be an argument that is brought to bear when there's a theory that the speaker likes that can be justified on originalist ground, essentially pushing the problem of a person sort of advocating for their policy preferences into the issue of what they advocate for. And so the way I look at constitutional interpretation, the question is, what are ways out of that problem? And I think there are two basic ways out of that problem. One is strong adherence to stare decisis. Follow the cases wherever the cases go, even if you really, really don't like them. And that is a way of interpreting the Constitution in a way that is not merely having each judge follow their policy preferences under the guise of some grand constitutional theory. It's not a great answer because it doesn't mean you get back to some theoretical norm. In fact, you lock in results that you may think from a first principles standpoint are bad. But I think it is a better alternative than picking and choosing things for which to be an originalist and then leaving the other things behind. And so it is a way of avoiding the problem of individuals pushing individual policy preferences into matters of constitutional law. The second approach, I think, that similarly satisfies this goal is that of sort of Thayerian judicial restraint. Letting the legislature do what the legislature wants to do unless it's clearly forbidden by constitutional law. So that would be really the traditional, I think, sort of Frankfurtian, Thayerian, Harlan, whoever you want to label this on, judicial conservatism being not intervening where the Constitution does not clearly say that judges should intervene. It's not a perfect answer either, because of course, what if the judges should be intervening? There's always going to be the question of what's the proper theory of interpretation. Judicial restraint being primarily a thumb on the balance, thumb on the scale rather, of if it's not clear that it's unconstitutional, then the default should be that it's constitutional, essentially taking the presumption of constitutionality particularly seriously. Neither of these approaches, stare decisis or judicial restraint, are sexy theories. They're not dazzling. They're the kind of boring things you hear about when you listen to or watch judicial confirmation hearings. It's the kind of mainstream, boring things that the political system seems to like. And I think it just so happens that those mainstream, boring things are actually the best of the alternatives in terms of constitutional theory, or I should say maybe the least bad of the alternatives, because they can, in fact, limit the role of the judge's personal opinion in interpreting the law. One natural question that all of this prompts is it actually possible for a judge to avoid inserting their personal opinion into their question, into interpreting the law? And I think it's possible to narrow it as much as possible. There are certainly areas in which judges are going to insert their opinion no matter what, but it's important for the theory of interpretation to try to minimize that, and I think its adherence to stare decisis and judicial restraint that best minimizes that instinct, which otherwise can easily sort of take over, even if there's a theory that each judge or justice adheres to that claims to be not one that's factoring in personal opinion. So that's how I would approach these questions. Thank you.
Well, like Orin, I'm not a constitutional theorist, so I'm not going to provide you with a libertarian theory of the Constitution, and it's just as well because Tom Bell already did that earlier, so you already got that today. But my work focuses on constitutional history and development, so what I thought I'd do today is tackle the following question. Given the current state of constitutionalism and constitutional theory and the constitutional water that's under the bridge, no matter what your theory of constitutional law or interpretation is, McCulloch versus Maryland, unfortunately, is not going anywhere. And the political realities, what libertarian goals are plausibly achievable in the near to medium term? These are going to be goals, I think, that are plausibly achievable because unlike a consistent originalism, which, for example, could question McCulloch versus Maryland, they are not terribly radical in their consequences. We're not going to be invalidating paper money here or repealing the New Deal or even questioning Gideon versus Wainwright. And they are either consistent with originalism, arguably consistent with originalism, or in the case of some First Amendment issues I'm going to mention, they follow naturally, I think, from modern Supreme Court doctrines. Why is this important? Because this means that these goals are constitutionally plausible in the near to medium term and that they don't require any radical shift in constitutional culture. And they're also plausible because the results are not going to be wildly unpopular, at least I don't think so for these. A lot of people aren't libertarians who like these results, and that makes them something the Supreme Court might be willing to do without sacrificing all of its political capital. So let's just start with ones that are consistent with originalism. So obviously, a hot issue now, limits on federal power, healthcare reform debate. We've all heard about that already today and elsewhere. This could be the beginning of a new federalism that tries to define some serious, albeit non-originalist in the sense of going back to the original meaning, limits on federal power, or it could just be a blip that doesn't really amount to much of anything. Another thing that could be accomplished, I think, is the Contrast Clause could be revived. There hasn't been a good Contrast Clause case since 1978. What's interesting to me about the Contrast Clause is that the court has insisted that Blaisdell, the 1934 case involving the mortgage moratorium, is still good law. Blaisdell really wasn't that radical, if you read it. I mean, it may not be an originalist contract clause interpretation, but it still leaves room for a pretty viable contract clause. And since the Supreme Court itself insists that it has never overruled or even modified Blaisdell, let's go back to Blaisdell. That'd be great. Non-delegation doctrine. Court has not expressed any interest in non-delegation, I think, because it can't really figure out a good principle. Here's a good principle for you. Before any regulation goes into effect, Congress has to vote on it. You don't have to abolish the administrative agencies. Everything can stay exactly the way it is. Instead of the regulations becoming law automatically once they're published in the Federal Register, Congress has to vote up or down. Another thing that I'd like to do is overturn U.S. term limits versus Thornton. It's not like Congress has distinguished itself so well in the subsequent 16 years that I would think that the dissent there made a big mistake. And here are a few that are arguably consistent with originalism. The Takings Clause. Let's overturn Kelo. We get not only conservative support, but from a lot of liberals, as Ilya has pointed out. And as Ilya I think, is trying hard and probably succeeding at showing us that Kelo and a greater role of the court in policing regulatory takings is actually consistent with the original meaning of especially the 14th Amendment, if not also the 5th Amendment. The right to earn a living free from government-sponsored monopoly. This is not bringing back Lochner. This is not a general right of economic liberty, but the right, as expressed by the Slaughterhouse dissenters very specifically, to not have the government throw you out of a gainful employment on behalf of monopoly interests, goes way back to at least to the statute of monopolies in 1689. I think it would be a reasonably popular thing if you limited it to that context. And here are a few that are not at all consistent with originalism, as I understand it at least, but build on current doctrine. We already have had a major victory on campaign finance reform. I don't know if the First Amendment speaks to campaign finance reform as the original matter, but if you're going to protect all the other things the First Amendment protects, there's no coherent reason not to put campaign finance reform, restrictions in the category of regulation of political speech, and we want to build on that. Freedom from anti-discrimination laws, as some of you know, I wrote a whole book about this. The Dale was a good start, although it's not really clear that the court would have been willing to apply Dale to broader contexts like laws involving discrimination against more popular minority groups than gays. On the other hand, this is going to become an ever more important issue because there will be exponentially, I think, more conflicts between traditionally rendered civil liberties and anti-discrimination laws as the gay rights movement continues to rack up successes, and you will inevitably have untold number of conflicts between religious people and organizations trying to conform to their traditional religious values and gay rights organizations insisting that the anti-discrimination norms must be respected. Finally, the holy grail, the most controversial, maybe the one that is not plausible in the near and medium term, maybe wouldn't be that popular, but if there's one thing this is the one thing I'd love for libertarians to accomplish. I think it's consistent and, in fact, naturally follows from modern First Amendment doctrine. Public schools are, by the reckoning of their own strongest supporters, means of indoctrination. That's why they exist, and that's what they do. They indoctrinate you to whatever values the majority of whatever jurisdiction you live in happens to want to impose on children. Now, I'm not saying public schools are unconstitutional, but I am saying that if the government is going to have a required school attendance, have a monopoly system where you have to attend their schools, they have to give you an out for both freedom of speech reasons, to not indoctrinate you into certain political or social views, but also for religious freedom reasons. Now, if the public school model in this country is based on Protestant sects, where to be a good Methodist or whatever, all you need to do is go to your church once a week and do good works and believe in Jesus and all that, and that's cool. But there are a lot of religious minorities where religion is really a matter of day-to-day, moment-by-moment living, and public schools just don't accommodate that. So for both freedom of speech and freedom of religion reasons, I think that the First Amendment not only allows, as the Supreme Court has already held, the government to give vouchers for private schools and religious schools, but also requires it. I should point out that for libertarians to succeed on these issues, they will need allies. Conservatives are natural allies on most, maybe all of these issues, but many conservatives, especially followers and fans of Robert Bork, are still stuck in a warmed-over progressive ideology that is not really conservative at all in its origins. This manifests itself in concern over judicial quote-unquote activism per se, channeling old-style progressives like Oliver Wendell Holmes, Justice Louis Brandeis, Justice Felix Frankfurter, who no one in their heyday would have confused with being constitutional conservatives, rather than in creating a constitutional ideology that is reasonably coherent, politically feasible, and consistent with traditional pre-progressive constitutional ideology. That's starting to crack, fortunately, in part because of originalism, in part because it's a lot harder to be against judicial activism when you control the courts. But more generally, I mean, I'm very optimistic in a sense because we have a great example of what's happened recently. Just like libertarian views have influenced the Tea Party conservatives to return to conservative limited government roots, libertarians, I think, need to and are doing the same with conservative jurists. Thank you.
Thank you. In order to assess whether there's something better than originalism out there, I think you need to answer three questions. Why would you want to be an originalist to begin with? What do you want originalism to do for you? Two, why does originalism not do that? And three, what would do that better? And so those are the three questions I'm going to discuss today. Why would someone want to be an originalist? Well, I'll tell you the reason why I first wanted to be one when I became enchanted with originalism in law school. I bought the judicial restraint thing, that originalism is good because it's more democratic. It minimizes the instances in which judges, unelected judges, will replace the policy preferences of the public with their own preferences. I think that's the reason why most people are drawn to originalism, and it certainly was the reason why I was drawn to it when I first became enchanted with it. I have come to the view that originalism doesn't serve that purpose very well, and I've come to that view because I think originalism is very indeterminate. There's just as much ambiguity in history as there is in pretty much everything else, outside of one context, a context where asking the question whether something that existed at the time of the founding is still constitutional today. Outside that context, where I think there can be some clarity from originalism, I think the originalist methodology leads to great ambiguities. It becomes a hypothetical inquiry. When you're dealing with practices that did not exist at the founding, it's very hypothetical. It is a question of what would the founding generation have thought. You end up looking at what were the purposes of constitutional provisions. It becomes very indeterminate. And I think in face of ambiguity, judges tend to decide cases consistently with their experiences and their worldviews. And this leads even originalist judges to replace the policy preferences of the public with their own policy preferences. And as an example of that, the Heller case, which is often heralded as a great success for originalism, I think Justice Scalia could have written any of the opinions that were written in Heller. They were all quite historical. And that case was decided 5-4, very consistent with the judge's own ideologies. And so I became disenchanted with originalism. I think it does not serve the purpose of restraining judges from imposing their own policy preferences on others. What would do a better job of that? Well, my own view is that methodological approaches to judicial restraint are basically doomed to failure. That if you're looking for some kind of methodology to restrain judges, like look at the history, like only strike things down when they're clearly unconstitutional, you're going to end up with enough ambiguity that judges will be able to do what they want to do in those cases. You can't rely on methodologies to restrain judges. Instead, I advocate turning to what I call structural judicial restraint. You have to impose structures that prevent judges from replacing public preferences with their own preferences. So let me give you some examples of what I mean by these structures. One example is a voting rule. So instead of saying judges only strike down a law if you think it's clearly unconstitutional, let's require a supermajority before the Supreme Court, for example, can strike down an act of Congress. Instead of 5 votes, let's say you need 7 votes. You need 8 votes. You need 9 votes. Imposing structures to prevent judges from replacing public preferences are more effective than relying on methodologies. Another example, jurisdiction stripping. If Congress doesn't like the Supreme Court's preferences on public policy, find a new court. Take the case away from the Supreme Court, leave it in the state courts, for example. I think voting rules and jurisdiction stripping are probably constitutional ways that Congress could impose structures that prevent judges from replacing public preferences. Another example, and this would require a constitutional amendment, obviously, would be to get rid of life tenure, to change the judicial tenure structure, to give judges an incentive, federal judges an incentive, to care more about public preferences than they do under the current system. And so, if the reason why you're contemplating being an originalist is that you think it's the more democratic, more restraining way to go, then I would suggest that you might find more success by relying on these structural mechanisms instead. Thank you very much.
I'll begin by asking each a question to each of the panelists, and then we'll throw it open. To Patrick Brennan, I guess I would begin. I find your discussion extremely interesting, but rather, particularly for someone who found jurisprudence always a very difficult course, rather abstract. And I was wondering whether you might give us a concrete example of where you thought natural law, in any of the cases, a natural law approach might differ from an originalist approach.
I'm not sure, John, whether you're. I mean, I can come up with any number of areas or cases in which it's at least probable that the probable meanings reached by inquiring into original public understanding are inconsistent with at least some of the evidence that we have about the possibly eccentric but real intentions that the framers had. And so at one level at least, my argument is simply that it's inconsistent with respect for as I already said, inconsistent with respect for the law-giving rule, not to ask every question necessary to ascertain as strongly as possible what the real meaning was.
Well, I guess the reason I ask it, another reason I guess I ask it, I haven't actually seen a whole host of examples of where original intent does differ from original public meaning, and I'm just interested in and sort of pressing you to see whether your theory is really not, if we're talking about a bubble in originalism, a new kind of originalism, maybe natural law originalism.
Well, for example, on the very issue of whether the framers originally intended their intentions or the public meaning itself to be binding, the Jeff Powell point.
Okay. To Orin, my question, I was very interested in your discussion of the confirmation bias, and I think that's a serious problem with judging. I'm just wondering how looking to precedent solves it. I mean, there may be a lot of difficulties in understanding what history is, but there's a lot of precedent now with 200 years, and you can go out and look at your friends and not cite, and indeed, to make the problem more acute, I believe there's a famous law review article by Judge Easterbrook which suggests that it's not even possible for 9 judges, even current court, one court, given of course there's precedent from all sorts of different courts, to come to consistent views, or it's just not very likely given that there'll be shifting majorities. So isn't this actually not a help with what you understandably are trying to do, to try to at least diminish confirmation bias? It's just not a very good mechanism for that.
I don't think so, and here's why. So there are a lot of cases. Let's just take a typical docket on the Supreme Court. There are a lot of cases that I think where there's a clear better answer from a precedent standpoint, where if you look at all the precedents, you say they tend to point in a particular direction. So I think that would make it the stronger answer from a precedent standpoint, and therefore a stronger answer beats out a weaker answer, and therefore it is the answer that a straight stare decisis approach would tend to support. Where occasionally there are cases where it really is, you look at all the cases and you think there's no answer here. There's nothing. And in that case, I'm actually not that interested in that sort of case. I think they can do whatever they want. It really is sort of a flip a coin sort of case. So in that case, fine, they can do whatever method that if there really is no answer. Those are, I think, relatively rare, and I think the answers in those cases are going to be sort of less analytically interesting than the other cases. So I do think that straight adherence to stare decisis actually answers a lot of cases, providing answers. And maybe you don't like the answers, obviously. There's all sorts of problems with sticking with prior decisions, which may include decisions that you don't think were decided correctly. But I think it often does actually yield relatively predictable answers.
But I just ask why you think that's. What about the feature of looking at precedent as opposed to text and understanding text through history that makes precedent clear. One could say, well, there's more of it, the precedent's thicker. One could say, well, the Supreme Court's a lot clearer. That seems not necessarily plausible to me, but I'd like to understand what the mechanism is that makes precedent, which suffers from some of the problems that I've discussed. It comes from different eras, even within its own era. I think Judge Easterbrook has made pretty persuasive arguments that it's not actually going to seem consistent. What do you think about the body of stuff of precedent is going to lead to this greater ability to avoid confirmation bias?
Yeah, I think it's the richness of the materials, usually there are a lot of cases, or there's a good number of cases, all extensive explanations of where they're coming from that can be situated in some context. Oftentimes opinions will summarize the state of doctrine in a way to try to bring together what the prior cases say. And I think that tends to add an amount of information that can be relied upon to figure out where the current state of the law is.
Okay, so to David Bernstein, I guess I have two questions for you. One is, I thought it was a very interesting presentation. I certainly think that you performed the interiorum function. I mean, anyone who's a non-originalist would listen to this and be really worried what non-originalism could do in the wrong hands.
We're pleased.
But I guess my first question is, what do you do? Because it did sound, yours seemed very much most like what at least I imagine a lot of non-interpretivists do. They have a list of results they like, and they think non-interpretivism will get them to that. But some political scientists have worried, beginning with the Hollow Hope and other kinds of books, that this actually could lead to backlash, and actually, in the long run, because these decisions are made without often democratic legitimacy, that they may actually undermine originalism. Now, that may be not true of some of them, but isn't that a problem with this kind of political, almost overtly political approach to judging, even given, which I'm accepting, your objectives, which is simply to get to the most libertarian state you can?
Right, and let me just preface by saying that I've become convinced over the years in doing my constitutional history scholarship that I'm not sure what the framers intended in this regard, but from the beginning of American history, what the Supreme Court has done in practice is reflect the views of the political coalition that put them into power. So if, I think liberals have no interest in libertarian ideas, with few exceptions nowadays, like Lawrence, and therefore they're hopeless. So if the conservatives are in power, the libertarian goal should be to say, well, we want to influence what the goals of that coalition are. And it really doesn't matter whether you claim to be an originalist or claim to be a textualist or claim to be a precedent-based. What the Supreme Court justices will, in fact, do is stray not very far from the views of the political coalition who put them into power. So if you're a libertarian, you're sort of cynical about this process, as I am, cynical, maybe realistic about this process as I am. Your goal is to try to move the debate in the direction you prefer, rather than arguing about how many originalist angels could dance on the head of a pin. I mean, I think conservatives in the 60s and 70s thought, we're going to show those liberals, they've been talking about judicial restraint and all the stuff that Orin talked about, Thayer and all this for generations, and now they're not doing it, so we're going to point out how hypocritical they are, and they're going to go back on that. You know what? That doesn't work. No one cares ultimately about constitutional ideology once they're in power. They're concerned with how, within the limits of current constitutional culture and political viability of the court, and without being too outrageous in our use of sources and all that, we can advance the goals we want to advance. Now, as far as that one thing that one must keep in mind in that regard is that yes, if you do stray too far and you misinterpret the strength of your political coalition and what your political coalition is really about, and if you're in the case of maybe some burger court decisions, you think that culture is going one way and it may not be going that way, or at least not as fast as you anticipate, you do risk some sort of backlash. But I don't think that's inconsistent with the view, and that's why I acknowledge at least my last thing about the public schools might be a little radical. Most of these things I don't think I took terribly radical positions. I don't think there'd be a big public protest about Congress having to vote on regulations. I think the average person would either completely not understand what that's about, or to the extent they did say, well, that's probably a good idea.
Well, I think your answer prompts my second question, which is, despite the fact that your wish list of libertarian objectives reminds me a lot of just a different list that the left might come up with, the left, largely in their non-interpretivist modes, at least comes up with some slogans, with something that tries to not suggest, to not admit what you seem to be admitting. This is all about getting using our coalition and getting the results we like. And so I'm wondering, don't you think that even if that is your objective, to actually fulfill that objective, you actually want to present what you're trying to do under some kinds of more principled sense of judging, rather than have simply a set of cases or a set of initiatives that you'd like the Supreme Court to fulfill. Even to meet your objective, it's very useful to have at least a patina of neutral principles.
Absolutely. That's why I preface by saying I'm not a theorist. The job of the theorist is to provide the patina for the political people to pretend they're not engaging in politics.
Well,
This is the Federalist Society, right? Just
full points for honesty. So to Brian, I guess the question I have for you is, well, if you're really concerned, or at least let me begin with this question, if you're really concerned about democracy and making sure mechanisms for that, why, it seems that you might not be, after your disenchantment with originalism, might not be so sympathetic to judicial review itself. Isn't that the best structure? In other words, we have a lot of democratic systems. We can imagine them without judicial review. Why isn't that even a better and a simpler structure, one that's even harder to manipulate and harder for people to hide behind, as all those other advantages? I'm not quite sure why you're not driven to being a more radical Democrat with a small d.
Well, I think it is better. I think it is simpler. It's just not practical.
I see. So
I think a voting rule asking them to have 6 instead of 5 or 7 instead of 2 is much more practical than getting rid of judicial review altogether.
I see. So, but your regulative ideal, if I might ask, would be really no judicial review at all.
If your goal is restraint and democracy, then I think it does lead you to the popular constitutionalists who question judicial review. I think that's right.
Well, let me ask you then, though, about what do you do about I think I understand why you might have become disenchanted with the constraint idea of originalism. I think it's fair to say that the constraint idea of originalism comes maybe from what David Bernstein regarded as that discredited progressive originalism from Robert Bork, right? That was often emphasized, the constraint. I think it's fair to say that some of the new originalists, I dare say some of the originalists who's even sitting closer to you, have some other justifications for why to be an originalist that don't sound in judicial restraint. So since your whole theory seems to be dependent on defeating originalism because you seem to feel a kind of pull of it, I'm wondering if you could talk a bit about these other justifications and why you don't find those to bring you around to being an originalist still today.
Well, I mean, I think, frankly, I've not thought as much about the other justifications as I have about the democratic or restraint justification. But I do think the answer to this question does require everyone to kind of ask themselves to begin with, what are you trying to get out of your approach to the Constitution and constitutional interpretation? You've got to answer that functional question first before you can choose which methodology or which structural mechanism that you're going to adopt in order to serve that purpose. And so I think if you have different goals in mind for your judiciary, then you could be led to different results, including perhaps a result that is originalism. But I have not studied those other justifications, John, in great detail. Perhaps I should read more of your work.
Okay, well, on that note, I think we can then to questions from the audience. Ilya.
So, as some of you know, Orin and I have debated. As some of you know, Orin and I have debated some of these issues a number of times. So, I'd first like to thank him for a very thorough expedition of his views. But I do still have questions about a couple of issues. One is two interrelated questions. One is, under your theory, when, if ever, would it be justifiable for the court to overrule a precedent? Notice that this creates a bit of a dilemma for your theory because the court actually has precedent which outlines when they can overrule precedent. So it seemed to me if you accept that precedent, then that means that a lot of other precedent potentially could be overruled. If, on the other hand, you reject that precedent, then that also poses some problems for your theory. If you reject only the precedent that has to do with precedent itself, that's potentially problematic. Secondly, as I've pointed out in the past, I think there's some tension between the two pillars of your theory, namely precedent on the one hand and Thayer deference on the other. That, as you know, many of the court's precedents, including Gideon versus Wainwright, which you mentioned, but dozens of others, are cases where, in fact, the court has struck down statutes which probably were not clearly unconstitutional in the sense that Thayer thought. Now, I personally think many of them actually were unconstitutional, but they may not be unconstitutional in the very clear sense that Thayerianism has in mind. So when Thayerianism conflicts with precedent, which one do you choose and why? Thanks.
Yeah, great questions. You're absolutely right, Ilya, that there are both of the tensions that you identify. And I think maybe the way of dealing with them is that any of those choices are fine as long as the individual judge is not making the decision based on whatever their policy preferences are. In other words, I almost sort of propose a way, if you could strip away a person's policy preference and say, do you think that this is the right choice? Imagine yourself having the exact opposite policy preferences. Do you still think that that is the correct choice? As long as the person's policy preferences are not actually the source of their decision, I'd be fine with any way of dealing with either of those dilemmas. The real concern I have is with the manipulability of the theories to reach results which nicely match people's policy preferences. So I absolutely agree with that, and let's take the issue of the precedent on when to overrule precedent. I'm not suggesting that there should be that the rule should be never overturn any precedent under any circumstances. I think there are a couple of circumstances that become kind of easy. For example, technological change, where the significance of a technology will change the consequence of a rule, and then you can say, well, the older rule, which meant one thing at one time, now means something totally different, and we can restore the original purpose by having a new rule. So that's one circumstance where I think it'd be perfectly legitimate to overturn a precedent. But I think I'm more interested in the attitude of I want judges to be very much aware of the possibility of confirmation bias and the possibility that they're reading their own policy preferences into the law, and it's stripping that out as much as possible. And really the options that are left over, there are puzzles there, but as long as that part is stripped out, I'm kind of happy with whatever resolution is reached.
Could I ask you a follow-up?
It's very easy for people to bring back inner confirmation bias, even if they consciously believe that that's not what they're doing.
Oh, you're saying, is it ever possible to overcome the confirmation bias is essentially the point you're making. It may not be possible to ever do that. And I think it may not be possible to ever entirely root it out, but you can certainly work on it and do it better in some circumstances than others. And it may just be, I always like it, when a justice hires a law clerk who disagrees with them, or as Justice Scalia sometimes does, or just individuals that are constantly asking themselves, am I reaching this result because I like it, or am I reaching this result because it is the correct decision under the law? And it's that awareness more than anything else that I'm interested in.
Patrick Brennan has an intervention.
Just a follow-up to Orin's reply. What on your count is the most fundamental justification for this attempt asymptotically to eliminate what you call judges' policy preferences, but if we put it in a less question-begging way, to eliminate the prudential application of the judge's operation of practical reason within the context of the law that he has received. Why this fundamental commitment to elimination? That certainly wasn't the common law tradition's assumption at the time of the ratification of the Article III power.
And this goes back to exactly Brian's point about the importance of democracy. I mean, it's just a straight democracy rule. Judges should not be monkeying around in things that were otherwise left to the legislative branch. And the concern is that if judges try to take a sort of broader view of operationalizing their visions of what is within the legal culture and adopting theories within it, that they start, we don't want to live in a world in which judges run the show. We want to live in a world in which the public votes and we have a democracy, or at least that's what I think. I realize I'm in a room where some people may differ, but that's what's driving.
Okay, and then just one brief follow-up on that. What's the justification for, and I could be wrong about this, but this is how I take what I take your position to stand for, that we, including you, driving the van, are trying to out democracy those who intended the judicial power to be something closer to the common law model. What's the justification for that, if I'm right about what's going on?
I'm sure it ultimately just comes down to sort of a populist sense. Maybe it comes down to, between populism and democracy, some mixture of those is probably what's driving it.
Orin,
my question's for Orin, too, actually. What if the governing precedent in a given case is a case where the judge is straightforwardly promulgating his policy preference, if he's looked into the mysteries of the universe and pulled out the answer that comports with his soul? Wouldn't it be worse to sort of be further enshrining something that in the first instance was a straightforward expression of a policy preference? It would just be someone else's policy preference rather than your own?
Right. So this is, I think, one of the biggest the difficulties with stare decisis is that if the other guys have enshrined their policy preferences, why shouldn't we enshrine our policy preferences? Or why shouldn't we try to undo their decision? And I think I think the difficulty is, my concern was saying that if they did it, then we should do it, is that then you're just saying, listen, judging is just a matter of who gets to appoint the judges, and whoever gets to appoint the judges runs the show. And this is David Bernstein's crit Federalist Society theory of, and if we want a world where, listen, judges have power and we try to beat them and they try to beat us and we pretend that we're in a world of theory, then I guess if we want to all pretend, we can just keep pretending. But I don't want to be the idea of sort of pretending that there's all this theory and we believe in these following principles when we don't strikes me as a dishonest move. So that's why.
Very quick question, Orin. Could you name a justice you think has remotely approached your the way that you think judges should go about deciding constitutional cases in the last, say, 50 years?
Frankfurter, maybe close. Harlan, usually. No one perfectly, but that's why it's an ideal. So.
Steve Galbraith.
I wanted to ask anyone on the panel what they would think about the idea that there's a different burden of proof in constitutional cases when a challenge is being brought to the constitutionality of a state law as compared to an act of Congress. Because the premise of Marbury and of judicial review is that the Constitution is supreme law, and so it trumps anything else. If the constitutional text is unclear in a 14th Amendment case, and, for example, a challenge is brought, say, to traditional marriage, the fact that the Constitution is unclear in the 14th Amendment ought to leave the state law in place, because in the absence of a clear constitutional command, the state law would prevail. But suppose the Constitution is unclear in the necessary and proper clause in granting power to the federal government, and suppose further that the federal government imposes a health care mandate which Congress thinks is necessary and proper, but it's unclear whether it really is necessary and proper or not. ought not individual state liberty and property interests then to prevail instead of the federal constitutional claim? In other words, isn't the correct answer that there's a different burden of proof when you're challenging a state law and a federal law when the constitutional text is unclear?
Can I chime in on that just very briefly? I would have thought that you were going to go the other way with the burden of proof. It's very interesting. So I would have thought that it's more undemocratic, if you will, for the Supreme Court to replace the preferences of Congress than it is for them to replace the preferences of the people of one state. And so I thought I would see an argument for the burden of proof to go the other way. So it's very interesting that you stated it the way you did.
I also thought you were going to go the opposite way, because I thought what you were going to say was that you have a supremacy clause. Congress and the executive branch, for that matter, are co-equal interpreters of the Constitution because they are also federal interpreters of the Constitution. And therefore, except perhaps in the case of truly egregious error, the Supreme Court should defer to Congress. Whereas with regard to the states, well, state officials also have an obligation to follow the Constitution when they enact legislation. They, on the other hand, are not co-equal interpreters of the Constitution because they are state interpreters, and therefore, under the Supremacy Clause, the federal interpreters of the Constitution be out the states. I'm not saying that's right. I thought that's where you're going to go, but at least it shows that one can make the opposite argument once you start with similar premises.
Okay, Randy.
I have a question for both Brian and Orin, but I have an observation for Orin. I'm wondering if my existence isn't somewhat of a refutation of your theory, because I think you would probably believe that my argument against the individual mandate is simply reading my policy preferences into the precedents. And so if the problem for which precedent is the solution are people reading their policy preferences into it, I'm not doing it as an originalist this time, Orin. I'm doing it as a precedent guy this time, and so I'm Exhibit A for why precedent is subject to the same objection as originalism. In fact, in this case, I would say the original meaning with respect to this mandate is really clear. Nobody, even on the left, would disagree with that, but what we're arguing about is the uncertainty of the precedent. So that's just an observation.
And could I respond?
Yeah, sure, absolutely.
It seems to me, though, that you're making a precedent argument because you're forced to make a precedent argument, because you want to change things in order to get the real world closer to the theory that you think is correct, which happens.
No, it's just my preferences. It's just my policy. I have a policy preference against the individual mandate. That's the only motivation I have, and everything I say is simply a means to the end of adopting my policy preferences, right? If I say that's my motive.
No, I don't suggest that everybody is consciously thinking, I like X, therefore my view of the Constitution is X. I note that is, it so happens there is a striking correlation between the theories people adopt and their views. And I think you would agree that you're an example of your personal policy preferences are very libertarian. And in your view, the Constitution is a very libertarian document. And I don't think, it's impossible in any one case actually to say, well, this person is reaching these decisions for these reasons. But that high correlation, I don't think, is a coincidence.
No, I guess I just didn't hear the answer. Since you were responding, well, let me ask my question of both of you. The question I have of both of you, because I just didn't hear an answer to why I'm not a refutation of, I don't see why they have the same problem with precedent that originalists allegedly have of reading their policy preferences one way or the other. So I guess my question to both of you is, how would you interpret the Constitution? I've heard Brian talk about there's a voting rule of 7 votes, but presumably they're voting about their interpretation of the Constitution. So, and in Orin's case, there are times in which precedent doesn't govern and the Constitution must be interpreted. So I didn't actually hear either one of you identify a theory of interpretation that you favor or disfavor when these other things are not binding, which sometimes will happen. So what is your theory of interpretation? How should forget theory.
I would be an originalist in that setting. So, for example, an originalist, straightforward public meaning originalism is how I would approach it. But where there's precedent, I would follow the precedent.
That is an answer.
I just don't think methodology matters that much, which is the beauty of the structural rule. It doesn't matter what you do, because the structural rule will restrain the judges. My own view is judges end up most of the time doing what they want to do, regardless of what they're saying.
But how would you advise
So I
them?
would do what I wanted to do. I would be like them.
Yes, I'm sorry. Please, I don't. Your name and the
Tim Sandifer is my name. I think all the concern about democracy is overblown because the Constitution lays out very clearly what it's intended to accomplish, and democracy is not among those. The blessings of liberty, protecting the blessings of liberty, is the purpose of the Constitution, and so where that clashes with democracy, we should reject democracy. But sticking with democracy, I think the problem is that we're picturing the judges as if they stand outside the process and put a stop to the process when they don't. I think Professor Brennan is right that we have to see the judges as co-equals and as having a representative character, not the same kind of representative character as members of Congress, for example, but they are the reason why elected officials choose nominees for the Supreme Court is in part because we want to allow the people who are the sovereign to express their you might say normative views in law by having a judiciary that partly represents their normative views to law in law, right? So judges don't stand outside of democracy. Judges are part of democracy. They just make their decisions in a longer range view, just the way the senators make their views in a longer range view than do congressmen. So why should we, if we say that judges, my point is, it's not undemocratic to say that judges should construe laws in pursuance of certain policy preferences, because that is part of what they're intended to do in a representative republic. They don't stand there just to say this is the inherent meaning of the law unaffected by the public will any more than representatives are supposed to do that. They're supposed to take, at least when possible, to take existing doctrine and bend it in the direction of the policy views that were endorsed by the people in the form of their nomination to the court. Is that clear at all?
I wonder, though, wouldn't that be I think you'd have a stronger case for that if at judicial confirmation hearings the senator said, Judge so-and-so, what are you going to do when you're on the Supreme Court?
I agree with that
And the judge
completely.
said, I'm going to do whatever I want. I'm going to enact, I've got these policy preferences, and that's what I'm going to do, and I'm going to ignore the law.
But if he said, I'm a libertarian, right?
But
you're right, he should do that.
But to the extent there's a political check, I absolutely agree. There's some democratic aspect of the way in which politicians nominate and politicians confirm judges. So there is some democratic aspect to it. But I think it'd be the fact that judges generally announce a view of the Constitution which is not of that character cuts against the way in which that is a democratic theory.
Yeah, I tend to agree with Orin entirely on that. I think you're right, there's aspects of democracy in the way in which they're selected, but given that they don't tell us what they're going to do during the confirmation hearing, and given that even if they did tell us what they're going to do, it's not in any way binding on them because they have life tenure, I just don't think that's a very effective mechanism to accomplish these democratic goals. So the question is it democratic-esque? In some ways, yes, and the question is that enough democracy for you? For me, it's not, but maybe for you it is.
Well, I think this question raises something I've been with both Orin and Brian. Is where do you get your democracy imperative from the Constitution, or is it just a higher level policy preference? Because of course you might have an Aristotelian view that it's better to have a mixed regime. There are a lot of different views we can have. That's a policy preference too. I understand if you're getting it from within the Constitution, that may be kind of almost an originalist view. So that I'm looking for really the foundationalism of your views here.
Well, for me, I think everyone has to start with a premise. I mean, the reason why you go to the Constitution, the original understanding to begin with, to find out why you're doing things, requires a premise, requires a functional justification for doing so. And so I think we all, whether we want to admit it or not, have to have some functional reason for embarking on this enterprise, and I just happen to like democracy.
Orin?
It ends up being, Brian and I are not that far apart. I think it comes from a populist sense of the value of individuals participating in a polity and everyone having their voice and no one voice being stronger than any other. So it's that commitment.
It's a little stronger than just people participating, because of course this goes back to Aristotle's view of polity. He was very much, he thought that there should be a democratic element, but he thought there should be other elements too. And so you want not only a popular participation, you want the exclusion of other elements.
Well, not the exclusion of them. I'm not suggesting that there should be no judicial review. Just ultimately the value that is driving me to the focus of democracy is a populist ideal. I think that's where it's coming from.
For whatever it's worth, it seems clear to me that the reason that judges were given life tenure and whatnot, and the idea behind having a separate judiciary, unlike in Great Britain, was to have a sense that there will be the best men who are educated, who preserve society's values, who will be a conservative restraint on democratic fervor. And it turns out that in the last 30 or 40 years that the educated classes and the lawyers have turned out to be more radical than the public. But that is unique. That's unusual. That certainly wasn't the case for most of American history. It wasn't what the framers anticipated. And I think that one could, if this is you guys' defense of your views that we like democracy because we like democracy, I'm not sure how you could criticize judges for putting their views. Democracy, if it's just another policy preference, and it's an overarching policy preference that overcomes the role that judges are supposed to do, that's even worse in a sense.
Believe it or not, I'd like to agree with the last part of that. And a question for Brian and Orin. I mean, why isn't the right move for you at this point to follow something Randy Barnett has recently done in his work against the mandate and say, look, already in Chisholm, the court, Justice Wilson and others said, look, we're a conglomerate, an aggregation of individual sovereigns whose collective sovereignty comes from this additive quality, and that's why our view about our sovereign constitutional lawmaking power, that all these other things get made. I agree with David to come onto the scene and say, well, it's the preference of those who inherited the Constitution from those who thought that they were an aggregation of independent sovereigns doesn't do nearly the reverence for precedent that Orin at least has otherwise commended.
Comments?
I wasn't sure if that was
Okay,
So we take other questions.
in the front there. Would you tell your name if I don't?
Mark Scarberry, Pepperdine. It seems to me you don't get to interpret the Constitution without taking an oath. And that oath seems to me gives you a premise, if you're a person of integrity, that you're supposed to in some way try to figure out how this document is binding on you. I'm wondering, David, if your viewpoint isn't a parchment barrier approach on steroids. That you don't believe in unilateral disarmament, and you don't think it's possible to trust but verify, and so essentially there's no way to bind the other side. So you're just going to do what you need to do. And I also wonder, in response to John's question to Patrick, whether perhaps Brown versus Board, maybe Bowling versus Sharp, maybe even the dismantling of the Protestant establishment in the public schools, where there's some originalist argument on the other side, maybe those are cases where the public good calls for you to make a decision that arguably might not be a decision you'd reach based on an originalist approach.
So, I think there's 2 points here. One of which I definitely agree with, which is that Orin raised this and then disagreed with it, but I think he recognizes this point that it's pretty hard to push unilateral disarmament on someone. I mean, there's obviously a ratchet effect. If the other side gets the power and does what they want to do, then you just stop it there and say, we're not going to do anything what we want to do, we'll just stop what they do. Well, when they get the power again, they push it further, and obviously things are only going to go in one direction. And it's pretty politically unsustainable. I mean, what sort of political coalition is going to stand for that ultimately? If that's your constitutional ideology, they're going to, your supporters are going to toss out the people who believe in that and bring in some more active people. As for the oath of office, I mean, I do think people are constrained somewhat. There are external constraints on judges. They want to see themselves as adhering to the Constitution and whatnot. They're not, just purely putting out their policy preferences. But the question is, who gets nominated to the Supreme Court, who gets appointed and confirmed? It's not going to be theorists who have, true theorists who have a really strong view. Here's exactly what the Constitution says. Politics be damned. Political capital of the court. I know what the Constitution says. I'm just going to do it. You have, Thomas comes reasonably close to that, but Thomas was an unusual nominee in a variety of ways. And I think if he had been a little older and had his views expressed more on constitutional issues, he probably wouldn't have gotten confirmed. But the people who get confirmed are, especially nowadays, John Roberts. Here's someone who's obviously very interested in politics, managed never to say a word to anybody about his views on any constitutional issue for a good 20 years. That's an incredible political skill that I'm not sure if it's an admirable skill or the opposite, but it's really a remarkable achievement, no matter how you slice it. So cautious people who are within the mainstream of their political coalition, and therefore, if that's how people have to get elected, and you have to get the president to appoint you, and you have to have people within justice and all that who are all political appointees who like you, and you have to get through the Senate, it's not going to be surprising if the views of those people will tend to reflect the views of the political coalition that they're surrounded by.
In answer to Mark's question, I certainly agree with you about at least some of your examples about where a natural law intentionalist view and an originalist public meaning would lead. I hesitated to answer before because part of my point was that the real bite of intentionalism of the sort I'm defending doesn't just come on the comparatively sexy issues such as you mentioned. It comes up everywhere. And to take example that builds on something that David mentioned, on non-delegation, for example. I mean, we look at the practice of the early Congresses with respect to the delegations they made and what the court would uphold or not. I think that there's a lot of conflict in the evidence, but there's plenty of evidence there that something a whole lot more than an intelligible principle was required, and I don't think you reach that result if you take an original public meaning approach, at least not necessarily.
People who have not yet asked questions in the back there. I can't see your name. I'm sorry, I can't see you at the moment.
Lackland Bloom from SMU.
I see.
Consciously or otherwise, the courts over time have created a system in which they have precedent, text, original understanding, tradition and practice, doctrine, all these different methodologies which they can and do choose to use whenever the occasion fits them. Why would they ever want to change that? They've got it all.
Answers to this?
No, I mean, I think that there are two different questions, or there are a lot of different questions here. One is, why would judges want to do this? And actually, I think a major problem with my theory is that judges have no incentive to do this. In fact, judges have the opposite incentive. Because what I'm telling judges is that your job should be not only for life, but extremely boring. And I think there's something to a theory of that which is constitutionally interesting, which is that judges and justices will occasionally do things that are kind of novel and fun to keep themselves entertained in a life job. So I think the incentives are really against judges taking on my view. I just think that normatively it's the better view.
I can't see the hand. It's John Harrison. Yes.
Thanks. This question is primarily for Brian Fitzpatrick, but I guess a little for Orin Kerr, and I'm wondering about democracy and structural reform, and whether a process of judicial selection and confirmation that was more open about the process that David is describing would be adequately democratic, or whether the fact that they'd still have life tenure, and in particular the Supreme Court is so small that it wouldn't be satisfying. Would that move you in the right direction, and would it move you far enough to think, yeah, now they're a democratic institution, they don't do the kabuki, they've actually answered the questions, they've run on, this is my platform, paper money's unconstitutional, whatever.
I certainly think it's a move in the right direction. And I could envision a confirmation process that was very good, where the senator said, listen, if you're not going to answer our questions, we're not going to vote to confirm you. We don't care what party the president is. But I will say, the life tenure, I get very skeptical that anyone's going to adhere to anything they said during their confirmation hearings. I mean, there's been a lot of change in the views of Supreme Court justices over time. So I'm skeptical that if you keep the life tenure in there, you're going to get to a point where I would feel comfortable. But I certainly think it's a step in the right direction. How practical it is to actually achieve that step in the right direction, I'm not sure, because the political incentives are always to give your president a pass.
Gene.
I'm just curious. The one thing we have with originalism is it is interpreting the it's designed to interpret the Constitution, which is supposed to be the supreme law of the land, which is something which none of these other methods of interpretation really have going for them, and that is. There's no question there can be all kinds of problems with originalism, just as there are with almost any other kind of interpretation one can come up with. But I guess the question I'd ask is, doesn't originalism have the advantage that it's actually interpreting what's supposed to be the law of the land you're trying to, and if mistakes are made, they're made, and you try to do better next time. The other methods have the problem that it's hard ultimately to see, to me anyway, what the legitimacy of them is.
So John asked us not to spend our time critiquing originalism, so we didn't. But here I'm going to agree with Orin. So Orin had said, I believe it was Orin at some point, that if he was starting from scratch in 1789 or 91, he'd just be an originalist. And I agree, I'd just be an originalist. But what do you do when there's so much non-originalist water under bridge? Our whole society is built, our government is built on non-originalist foundations that no one in their right mind thinks we are going back on anytime soon. I mean, we're not overruling the New Deal, in our lifetimes, as far as I can tell. And if we did, we have to do it very gradually. So the question is, so what you wind up having, and I know Mike and others have some answers to this, but I don't think they've been adequately fleshed out. If you just do clause by clause, okay, we have a new clause, the Second Amendment, we could be originalist there. But what you wind up having in practice is, certainly with Scalia, even to some degree with Thomas, even the most originalist justices, they pick and choose when they want to use originalism because they believe it's impractical to be a consistent originalist. You have to be a faint-hearted originalist. And the question is, if you're a faint-hearted originalist and only use originalism based on unclear criteria, it's not really clear when Scalia pulls out the originalist gambit and when he decides to rely on tradition and when he decides to rely on precedent. Are you really being an originalist then? Or are you doing exactly what every judge does on all sides? I mean, every judge is somewhat originalist. There's no justice in American history who have disclaimed that they don't consider at all what they think the intent or meaning of the original intent or original meaning of the phrases were. So it becomes a matter of degree rather than a matter of kind, I think, and then it becomes a problem. Are you really, is that really originalism? Or is it just originalism is one part of your toolbox and you happen to use it a little bit more than liberals use it?
I just want to give everyone a chance who has not yet asked a question. Anyone who has not yet asked a question who wants to. Okay? Randy.
I raised my hand because I didn't see anyone else who had not yet asked a question. Mine is for Patrick, and it's possibly a friendly critique. It shouldn't be considered necessarily a radical critique, but it has to do with an argument that the abolitionists made when they were talking about constitutional questions, and not always the unconstitutionality of slavery itself, but they were debating all kinds of things like the Fugitive Slave Act unconstitutionality and constitutionality in the territories and constitutionality and slavery in the District of Columbia. So they had a lot of issues on their plate besides the literal unconstitutionality of slavery itself. And one of the arguments that was made most prominently by Lysander Spooner, but he was not alone in making this argument, was that the only intentions of the people that are existent at the time of the founding are hypothetical intentions, or what he called theoretical intentions, because there isn't actually a literal expression of the intention of the people itself. So you have to, or we might call them presumed intentions. And the best evidence of what was intended is the fact that people agreed, such as they, to the extent that they did, to be bound by this text. And unless the text has a meaning, independent of whatever subjective intentions they may have, there was nothing for them to agree with. There's nothing for them to consent to. So they weren't making a consent to what's in their head. They were they wouldn't say, well, in my head I would like it to be X, and so therefore when I say I'm bound to what's in my head. But no, they were consenting to the paper, the text. The text, the only thing they could be consenting to, because they're not consenting to the intentions of the framers don't have any authority, on your theory, don't have any authority. They're simply proposing to the people that the people would then consent to it. So why then, in order to determine what the intentions of what in your phrase, the lawgivers are, I by the way, am not all that enamored with that way of looking at it, but I'm operating within your system. If you're talking about what the intentions of the lawgivers are, why isn't the intention of the lawgivers identical to what the public meaning of the document was at the time they expressed their intent, such as they did? In which case, you wouldn't find any conflicts between intentionalism. You're simply, in a sense, providing a different normative grounding for original public meaning originalism if you accept that the only real evidence of the intention of this mass is the public meaning of the text to which they agreed. One last thing, I'll just say how Spooner put this. He said, an agreement to a document that had no meaning, independently of the person agreeing to it, is the subjective intention, is an agreement to nothing, really. So the idea of this presupposes the document does have a meaning independently of people's subjective impressions about it.
Well, it's a great question, and an adequate answer would take a long time. But I'll just be brief and hope that we can continue this conversation some other time. On my theory, and this came up only in a hurry in what I delivered. Strictly speaking, law is always and only in the mind, and whatever appears, say on the paper, is subject to critique on the basis of the best evidence we have of what was in the mind. And so if we hypothesize that we concluded that there was a scrivener's error in our Constitution, we would not follow that scrivener's error based on the evidence we have of the intent of those who, in my way of talking about it, promulgated the Constitution, because their intent that was the law, their collective intent that was the law, was not in fact embodied in the thing that came out of the printing press, and there is on my account no good or sufficient reason to bind the people by a mistake that was introduced into a piece of paper at the expense of the law as they intended it to bind themselves and others.
Just as a slight follow-up, and again, I'm trying to be helpful here, not hurtful, but if what we're talking about is essentially a presumed intent, because there is no literal means by which we know what the thousands of people who were intending things under your account really did intend to, then it would seem that you would in fact, and Spooner did make this argument, have some principles that would govern presumed intent. Like, for example, one of the principles he argued for was that nobody can be presumed to have surrendered to the general polity their most fundamental rights. I mean, absent a clear expression, it's kind of a clear statement rule, absent a clear expression that they've done so, we simply can't presume that any person would have done so, therefore they haven't unless it's shown. The same thing might be true with your scrivener's error idea. Nobody is presumed to have agreed to scrivener's error, and therefore we won't hold them to that. But where there is no scrivener's error, or where their fundamental rights have not been violated or surrendered up, it is the public meaning ordinary meaning of the English language at the time they were expressing their intent to it, which is what we deem to be the intentions of the lawgivers.
This is great. And part of the reason why I started out by saying that my view is very close to some versions of originalism. The latter, original intent, but in some ways original public meaning will often come out in the same place, but not because I apply a presumption, but because frequently we will have to hypothesize about what the original intent, and we do that, though, because we're using the best means available to learn what it is that was in the mind of the framers. My intransigent point is that we can't say that something other than what they intended and promulgated is the law.
Ilya.
So, this is a question for Brian. I'm sorry. This is a question for. Sorry, I keep forgetting to take the mic. Although I have a pretty loud and annoying voice anyway, so maybe it's better without the mic. But this is a question for Brian and perhaps Orin. Several of you have noted that your theory privileges democracy over other competing values, and that may be a debatable choice. I want to also ask about whether it might privilege one conception of democracy over quite a range of others. So the implicit assumption, if I understand you correctly, is that anything that comes out of the legislative process is ipso facto democratic and therefore should be deferred to, and that's one possible theory of democracy, but there are many others. And one alternative is that democracy requires informed public deliberation. If so, as I and others have argued, if you have Congress with nearly unlimited powers, in practice, most legislation doesn't have that kind of deliberation because it's impossible for rationally ignorant voters to pay attention to most of it. Another possible conception advanced by scholars like Rick Hills, there might be more and better democratic participation at more local levels. If so, limiting federal government power might promote that by leaving more open to the states. Another conception advanced by John Hart Ely and others is that a variety of judicial interventions might actually facilitate people's ability to participate in the political process through so-called representation reinforcement. That also justifies a more active judicial role. So not all of these theories that list are ones that I agree with. Some I agree with completely, others only partly. I only really agree with my own theories. But the point that I'm driving at is to more fully develop your theory, you would need to A, explain what your theory of democracy is, and B, why that theory should be preferred by constitutional interpreters to the many other alternative theories of democratic participation that exist there and that have been advanced by a variety of different serious scholars of democratic theory. I've only listed 4 different options, but I could easily list 8 or 10 more, and all of them backed by fairly serious experts in this field. So the democracy is itself a contestable and debatable concept, and I wonder if I could dry out more on what particular concept of democracy underlies your theory and why.
Well, I think you're absolutely right about all of that, and I'm open to many of those conceptions of the optimal democratic process. And I didn't mean for anything in my remarks to necessarily exclude, except perhaps the Ely version, what you said. So, for example, as I understand one formulation of the popular constitutional theory of the role of the judge, the Supreme Court can strike down legislation, but the Congress can reenact legislation. And if it reenacts legislation, then that's it. So you could imagine, but you could imagine a role for the court to facilitate some of these democratic values you've identified that's short of having the final word, for example, in striking down legislation. So you can imagine all kinds of structures that facilitate democracy. It doesn't have to just be, whatever comes out of the legislature is it. So I think I agree with much of what you've said, and I think, depending on how you think that a democracy is optimized, that's going to drive exactly how you want the structures and institutions to interact with one another.
A question from David Bernstein.
Yes, I have a question, and I think it's for Brian, maybe for Orin, although I think I may know what Orin's answer is. So I don't want to let you off so easy. So So the question is, my further question is the problem that the judiciary is undemocratic or that the Constitution is undemocratic? And here's the stark way of asking that. Let's say public opinion supports X, and you are a senator, and you believe on whatever theory of the Constitution you have that X is unconstitutional. Do you then say, well, and you have sworn the oath of office? Do you just say, well, I believe in democracy, so the Constitution shouldn't interfere with what the will of the people is? Or do you say, with my independent oath of office, forgetting anything the Supreme Court says, I have an obligation to interpret the Constitution. This isn't allowed. And furthermore, if the latter, what is your theory of constitutional interpretation as a senator or state legislature or whatever?
Well, I think you could opt for either one of those particular formulations and still lay claim to a robust democracy. Personally, I would do whatever my constituents wanted me to do. And so that's the end of the story for me.
Violate the oath of office?
No, because...
no Burke of no. What about Burke to the electors of Bristol? I mean, that's quite a radical conception of your view. That, in other words,
I think I'm the agent of the public. I mean, again, at the end of the day, when you go back and look at some of the founding documents on democracy, that the popular constitutional people have referenced. It's very interesting what they say always, this question, what if, the people want to do something bad? And the response they always give is, what? If the people want to do unconstitutional things, then we're in big trouble. Because the whole theory that we are promulgating here depends on the righteousness of the people. And so, I mean, that's...
you don't follow, you're unrighteous.
And so that's kind of where I come out on the whole thing, is that I think that representatives ought to represent and they ought to be agents of the public.
That seems surprising, at least as to go back to the original discussions. I mean, the democracy and the direct democracy, direct reflection of the people's will was a bad word at the time of the framing. Representation was a process of filtration. And that necessarily might lead to a gap between what the popular will was at any time and what representation was. So that it seems, again, to me, emphasizes the radicalness of that you are a radical Democrat that really can't be found anywhere in the founding.
Well, no, I think that's entirely wrong, John. I think the Neo-Federalists certainly had one view of democracy, but there were competing views. And so I don't think we can be so glib about it. I do think that there was a diversity of opinion at the time, and I associate myself with those that preferred more democracy to less.
Yeah, and I would, in response to David's question, I mean, my own views focusing on the stare decisis approach, for example, doesn't really give any. It doesn't really answer that question. I think it's perfectly fair for and desirable for a politician to have their view of what the Constitution requires outside of what the courts say. So I think it's a fair, independent check and sort of outside the theory that I'm offering.
Well, I think we've had a very vigorous discussion. I just think we'd have to thank our panelists who offered us great alternatives.